Hey, welcome back, everybody. It's Wednesday. It's Law and Legitimacy, and today is day 36 of United States versus Joseph Biggs et al. Yeah. I announced yesterday in court that I thought we were about halfway through and wondered aloud when the judge was going to let the jury know we were going to be here a lot longer than expected. Watching ice melt is my new favorite pastime. That's what it feels like in court some of these days. Can't talk much about the case because that would violate the rules. And we know what happens when we violate the rules. I get suspended. And that's not a good thing. So, interesting controversy this morning. Mike, I didn't give you a heads up on this, but apparently there's a little thunderstorm going on in Congress. House Speaker Kevin McCarthy announced his intention to release all 14,000 hours of audio or videotape, rather, that the House J6 committee had accumulated regarding the events. And now there is rumbling, according to a source close to Law and Legitimacy, that he's told some members, "Nah, I ain't going to do it." And that might violate national security. If these J6 lawyers want their tapes for their clients, they're going to have to go to their congressman to get it. And I'm like, huh?
That doesn't make sense.
This is, the United States of America versus Joe Biggs. I don't have to go to my congressman or his congressman to get discovery obligations. So I'll be addressing this in open court this morning. If those tapes have been released, that's news to me. I mean, there are reports that that McCarthy has given some of them to Fox News. Let's not play favorites with the truth, Speaker McCarthy. If you're sitting on 14,000 hours of tapes, you promised to deliver them to the American people. Speaker McCarthy, where's the beef? An old woman once said. Old man is now repeating it to you. Either put up or shut up, or at least stop whining now that you've been revealed to be a hypocrite. I don't have access to those tapes. None of the lawyers I know in the case do. McCarthy's minions are out running their mouth around town, heavy-handedly saying, "Oh, the lawyers can get them. All they've got to do is ask their congressman." I'll make you a deal, Speaker McCarthy. I won't play Speaker of the House if you don't play lawyer. That's not the way the litigation system works, moron. Anyhow, we've got a new law firm.
Hey! Before we move on, I wanted to ask about the Tucker Carlson connection here, because that was the original story, right? Was that McCarthy pledged to release, 40,000 hours?
14,000.
14. Of 14,000 hours of unviewed tape from January 6, 2021, in connection with what we're witnessing now in the seditious conspiracy prosecutions. But the first news that I saw, Norm, was his decision to release those tapes, or to hand those tapes over to Tucker Carlson and his team, and saying that he trusted that Tucker Carlson and his team were competent to filter through and get that information to the American public. Did you look at any of that?
No, I've seen that, but I haven't been able to confirm that has in fact happened. But I mean, it raises an interesting question from my perspective, because in the course of the litigation, there have been arguments in open court by defense counsel that the United States is prosecuting the defendants, and if they're in possession of information that sheds lights on these accusations, the United States should turn it over. The Justice Department has expressed frustration with what it has not received from Congress, and so if McCarthy thinks that giving it to Tucker Carlson is a substitute for giving it to the Justice Department, when a coordinate branch of government is prosecuting an American citizen, McCarthy's got cow feces in his ear, because that's just not the way the system works. And so McCarthy may well have given them to Tucker Carlson, with the claim, Tucker, you figure out what's what. But I think McCarthy promised a broader release of them, and to suggest that it's incumbent upon the defense lawyers to go to their congressman to get what McCarthy should just turn over to the Justice Department or to the lawyers is frankly ridiculous, and he ought to know better.
Yeah, and it's just interesting that he would publicly say that he was going to hand this stuff over to one news anchor in particular, and one that we know is just embattled from a partisan sense. I don't have anything negative outright to say about Tucker Carlson. I think he's an incredibly bright guy, very hardworking. I've enjoyed listening to some of his interviews with the likes of Adam Carolla and and whatnot, sort of away from the Fox News network. And I know that he's worked really hard to kind of to build something for himself down in Florida. But there is a brand here, and Tucker Carlson has been in the news lately, right? Especially this last few days in connection with the Dominion voting defamation lawsuit against Fox, right? And now Tucker Carlson's communications are subject to the discovery in that, right? And whether he was reporting as he actually believed, or whether he was stoking a larger narrative. So I think McCarthy's got a bigger problem here than might meet the eye. And not to mention who is going to filter through 14,000 hours.
Yeah, that's the real.
I think that's getting lost in a lot of this, because of course, Norm, working with Joe, he's incarcerated, but he still has to review all the footage that is potentially used against him, and that's difficult enough, right? Think about 14,000 additional hours that, for whatever reason, were not released to the public. There's a lot here, and McCarthy, I think, in terms of obligations, Matt Gaetz, this is your boy, right? This is the guy that you held out against. This is the guy that you said that you had in check, and you waited to confirm him as speaker with your small group there. Put pressure. What's going on? So,
I don't know what's going on. I just got an earload about all this morning, and to make some noise about it in court this morning. If McCarthy has in fact released those tapes to a news organization and hasn't done so to the Justice Department, then he's shamelessly playing pocket pool with the truth, and he needs to be called out on it. But hey, let's talk about the new law firm, Ramaswamy, Rittenhouse, and Rumble. Hi, I pick up the phone this morning to talk to Mike, and the receptionist says, Ramaswamy, Rittenhouse, and Rumble, how may I direct your call? And I'm like, how may you direct my call? How can you say that so quickly first thing in the morning? Vivek Ramaswamy, running for president of the United States. That is interesting to me. Ramaswamy is a young tech entrepreneur, Harvard and Yale graduate. He's acquired wealth early in his life and has been an anti-woke warrior of late for the last couple of years. I think he's even written a book on it, which I haven't read. And so it was which I promise I'll try to, folks. If somebody will tell me what the title is. I'm interested in what he has to say because I'm anti-woke. And he announced his presidency with language that is near and dear to any Law and Legitimacy listener. We've celebrated our diversity so much that we forget all the ways we're really the same as Americans, bound by ideals that united divided, headstrong group of people 250 years ago. I believe deep in my bones those ideals still exist. I'm running for president to revive them. I'm watching Ramaswamy. Now, I can imagine the pundits having a lot of fun with this. Ramaswamy for the swamp, and I think in middle America, there are going to be a lot of people saying, Vivek Ramaswamy, what kind of name is that? But, let's be real. Most of us have come from elsewhere, and we've overcome the various waves of xenophobia attendant to our arrival. I am interested in what Ramaswamy has to say, and I'll be watching. But here's my fear. Ramaswamy may be a great diagnostician, but I'm not sure he's a great physician. And what do I mean by that? I told you earlier in the week, yesterday, in fact, Tuesday, which I mistook for Monday, because we'd had a legal holiday and no court on Monday, that I recently just read a critical study of John Locke, Richard Ashcroft's book on Locke, and Ashcroft went a long way to dispel the notion of John Locke as a radical individualist and tried to create a communitarian Locke. And that communitarian Locke was made possible by his commitment, according to Ashcroft, to a notion of natural law and also to revealed truth. And so in natural law, we're supposed to be able to know that by reason rightly applied, that our purpose is the common welfare of mankind. And thus, when we're left to our own, we're not left to be licentious. That is, we're not left to follow our own desires wheresoever they lead. we are set free to follow natural law. And natural law imposes common obligations on us, all common obligations to seek the collective good. Ramaswamy's preaching, as it were, from that vein. But is he preaching to an empty church? Because I don't believe that we have a common conception of reason or a common conception of right, much less any notion of natural law left. And I don't believe we have a sense of reverence for a revealed truth, wherein the potter says to we pots, I've made thou thus, and take what I have to offer with gratitude. I don't see that move in American politics, and it may be that it's been erased by deeper intellectual currents. We've talked here about the bottom falling out of pluralism. You'll recall post-Locke, Jeremy Bentham in the 19th century once referred to natural law as nonsense on stilts. And we now speak in terms of expressive individualism. And we have in our society a collection of people, each determined to realize themselves in their own idiosyncratic version of the good. And anyone who dares to criticize somebody's version of the good is held to have broken the communal pact to diversity, equity, and inclusion. rearrange the letters to diversity, inclusion, and equity, and you get what may be happening to our culture. It dies. There, in the absence, as Ramaswamy would tell us, of some common collective vision of the good, where do we go? So I don't know. I'll be watching and studying the Ramaswamy campaign very carefully to see if he can address this deeper cultural riddle. He's a young guy. The Constitution says you got to be at least 35 to run for president. And I've been reading debates from old newspaper columns about the founding and among contemporary Americans at the time about whether to ratify the Constitution. And they thought the 35-year-old age limit was good because we'd get to know about a person. They would have proven their character a little bit. We don't want callow youths like Mike under the age of 35 running because they haven't had a chance to stumble, fall, rise, and pick up their boots and walk. Ramaswamy certainly has. He's come on like gangbusters. Vivek, we're listening, but don't just tell us what's wrong. Tell us what's right. And it's not enough to hearken back to the days of our founding and to engage in glorification of the dead. That's necromancy. What we want is a living constitution that pays fidelity to enduring principles, and that is a synthesis that has yet to be made in any meaningful sense. We struggle to do it in our left-handed way here on Law and Legitimacy from time to time. But Vivek, you want to preach to the country? We're listening. Let's see what you have to say.
Yeah, so I've got up on the screen Strive Asset Management. So one thing that I think is important for us to know about Vivek, and I love the name, Vivek Ramaswamy. That's easy. He's going to be swimming.
No. It's a Saturday Night Lights skit. though. I want to talk to my president, Vivek Ramaswamy. Yes, I'd like some of the lamb curry. No, Mr. You can just see it coming,
Absolutely. Well, so here's what we know now. Ramaswamy, I thought the name was actually familiar. As odd as that sounds, I thought, and he may have appeared on a podcast I listened to, but it was, and I recognize it because of this, what I have on the screen. So Ramaswamy, he's Harvard educated. He's got his associates in biology. He's Yale law educated. And then he's also the co-founder of Strive Asset Management and its executive chairman. So they're a management firm that was actually backed by both Thiel and JD Vance. So both of those names we've discussed on this podcast before, right? JD Vance just a few days ago in discussions with some of the things going on in his world, Ohio, et cetera. But Peter Thiel is a larger cultural force, right? Co-founder of PayPal, co-founder of Palantir, author of 0 to 1, Stanford professor, entrepreneur extraordinaire, Peter Thiel, right? Peter Thiel that backed the lawsuit against large publication to take them down after
Gawker,
after he was outed as gay. And obviously it wasn't that, it was the Hulk Hogan incident, right? So we've got some people behind Strive Asset Management that have some real principled movement in their day-to-day life and professional career. And what's interesting, Norm, about Strive Asset Management is that they were actually established as sort of an alternative to the asset managers like BlackRock, right? And the larger institutional firms that have really started to push funds into the ESG category. So their Strive Asset Management, as I understand it,
and ESG means,
environmental, social, and what is that third? Whatever. It's basically the DEI of investing. Environmental, social, and governance, ESG activities. So ultimately, Strive recognizes that people who have their money in sort of mutual funds and certain investment portfolios that are managed by perhaps a third-party fiduciary or whatever else aren't necessarily aware that their money is being invested in a way that is to their long-term detriment, right? And so Strive Asset Management's value proposition is thus, we will actually create an alternative and we will market that for the average person, and we're here. I think it's interesting now that we live in a world where the likes of Donald Trump kind of gives rise to another outright capitalist and Vivek Ramaswamy, right? And someone who's doing it, in close connection with Peter Thiel and JD Vance. So I'm interested. I don't know that he said anything in the video that he put up or published yesterday that was particularly invigorating. I thought it was a very well put together video, but if I'm honest, it felt like it was just sort of built on a data algorithm, right? Like,
well, it might be
kind of music. Here's the images, da 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 da. So I do think that we'll need to see a little more soul out of Vivek before I'm really sort of in his corner. But I am interested.
Well, and here's the question I have, which is going to sound ageist, and I apologize to you in advance, Mike. He's young. I mean, how much soul has he acquired? What has he read? When he gives a nod back to the founders, is he doing anything other than a curtsy in the direction of a place where he thinks he'll find votes? Tell us who you are, Vivek. Preach to us. Show us your soul. Tell us what you think about America and your vision for the future. We're listening. We may even buy. Hey, let's talk really quickly about the second member of our new firm, Rittenhouse. We find this morning that Rittenhouse is riddled with litigation. No, this is not your Beijing correspondent. Kyle Rittenhouse has now been sued a couple times by the estate of one of the young men he killed in Kenosha back in the summer of 2020, and now by a survivor of the shooting, Gage Grosskreutz. And in both lawsuits, and you think, well, wait a minute, sued for what? Rittenhouse was tried and his self-defense claim prevailed. In order to win on a claim of self-defense, you have to show that you are in imminent or immediate risk, fear for your own safety, and that you responded in a way that was reasonable. A jury rapidly concluded that Rittenhouse shot in self-defense, and as unfortunate as it was that two young men died and a third was injured, in effect, they had themselves to blame for their attack on Rittenhouse. Now, those sound like harsh words, but that's the only reasonable conclusion you can draw from those verdicts. Many people were upset with the verdicts and regard Rittenhouse as a murderer. Mr. Rittenhouse did take human life. That's homicide. Murder is wrongful taking of a life. If you prevail in a trial and you have killed in self-defense, that self-defense is a justification, and it doesn't transform the homicide into murder. But for political purposes, Rittenhouse is always going to be a murderer. And so we relitigate the summer of 2020 suddenly. Those images of cities burning with reporters talking about mostly peaceful protests sum it all up. Rittenhouse came to a town to help protect property owners because in the eyes of many Americans in the summer of 2020, while the rest of us were locked down, the streets were turned loose to social justice warriors who took cities under, who took liberties with the property and the lives of others. And some people were frustrated enough to want to strike back. Rittenhouse went out to walk the streets to provide property owners with protection. Should he have done that? Well, maybe not. Nobody asked him. But, and this is the point of the lawsuits against Rittenhouse, did the municipal and county officials responsible for the public safety condone Rittenhouse's effective vigilantism that day? And in that act of condemnation, did they cloak him with the authority of the state? Did they aid and abet him in behavior that verged on lawlessness? And that's the question these lawsuits will challenge. In a federal civil rights action, for example, there is no such thing as vicarious liability. A city is not liable for the tortious civil rights violations of its employees simply because their employees committed them. That's a McDonald's sort of analogy. A McDonald's employee, McDonald's is liable for the torts of its employees for the most part. In a municipal context, you have to show that a municipality endorsed, condoned, or had a policy embracing unlawful behavior, and that when it engaged in that behavior, it cloaked an individual in the mantle of state authority, and thus the county, the claim will be, in the city of Kenosha, the claim will be, is liable for the deaths and injury that Rittenhouse caused because they condoned the presence of an untrained young man on the streets armed with a weapon to handle situations that he hadn't been trained to deal with and he wasn't prepared to deal with. So it's lightning rod litigation. I think we'll relitigate the summer of 2020. And there's one of those iconic photographs. Mike, go back to it just a second. A city burning in the background, and many of us were told they were mostly peaceful protests. Plenty of Americans sat in the summer of 2020 while quarantining with their masks on and waiting to die, watching people rampage through the streets and say, wait a minute, what about the quarantine? Only to be told, well, systemic racism is a public health crisis too, let it burn. I don't know. I had pretty raw feelings in the summer of 2020. I think the Rittenhouse litigation is going to force us to relitigate all of these things once again on the cusp now of the 2024 election, while Vivek Ramaswamy is telling us about his vision for the future, and Kyle Rittenhouse fights for his fisc with the city of Kenosha as a co-defendant.
A couple things here, Norm. Number one, I'm always reminded of what a fulfilling experience it was to be a party to your interview of Mark Richards, Kyle Rittenhouse's defense attorney up in Wisconsin during all of this. So after that trial had concluded, we were fortunate enough here on Law and Legitimacy to host Mark Richards, and he is a consummate gentleman. I'll make sure that I'll actually republish that for our viewers. I'll try to throw that on YouTube and on Rumble. It's just the audio, and I'll also republish it on Spotify, Apple Podcasts, and Google Play, etc. But that was such an enlightening look at the law in conjunction with what was really a political flashpoint with
and what a fantastic lawyer he is.
Oh man, he's the best. He really is the best. And I think I actually mentioned to you in a text message, several months ago that that J6 needs a Mark Richards, and that was just such a nod to how sober of a litigator he is. Just a complete machine. Total respect for that guy. The other thing with this, Norm, we aren't talking about this Rittenhouse stuff from a criminal perspective at this point. This article does a lot to talk about the posture of the criminal proceedings against Rittenhouse and sort of a historical timeline of that. But we are talking about just a garden variety plaintiff's suit. And I'm assuming it's going to be there'll be a number of things asserted, but mostly negligence. Am I correct there?
Well, yeah, negligence, recklessness, there could be intent too. But remember, you have to prove it by a lesser standard.
That's right. And that's why I wanted to bring that up, because we're not talking about beyond a reasonable doubt, which is the standard attendant to criminal prosecutions. This is going to be more likely than not, or by a preponderance of the evidence, in other words, which leaves a jury considerable room. Now, I don't know if Wisconsin, in the negligence context, I don't know if Wisconsin is what's known as a contributory negligence state. In other words, does Kyle wield a potential defense against liability because the plaintiff was he himself negligent to some degree? For example, here in North Carolina, we're a contributory negligence state. So if a plaintiff is even 1% negligent, they are barred completely from recovery. Most states are comparative states where there is a relative proportioning of liability between the parties. So I think that Rittenhouse is much more vulnerable from this perspective. There is no shortage of imagery that a plaintiff's attorney will be able to show to a jury, and certainly Rittenhouse has made the public media circuit over the last several years. I worry for him. I think that the buzz and the shine has worn off of his early fame, and most people aren't going to be there to have his back with this.
Well, we'll find out. I mean, I just think we will end up relitigating the summer of 2020. Hey, let's move. I wanted to cover a number of topics today, and we've been ignoring Rumble and the hateful conduct stuff in New York. I've been ignoring it. Mike, what's going on?
Well, Rumble and locals, it's Volk. We covered this a little while ago, and I guess my link here has expired on ECF. So look at me being prepared. But ultimately, Rumble and locals sued Letitia James and the New York state of New York to prohibit the enforcement of what is known now as a hateful conduct law, and that law was set to be enforced in early 2023. So when we originally covered this, I think I said, hey, this is going to be something interesting to follow because Rumble is asserting that they are going to be harmed having to enforce this policy, which requires social media companies like Rumble, like locals, like YouTube, like Twitter, et cetera, doing business in New York to undertake certain burdens with respect to users and complaints of alleged hateful conduct on their platforms. Rumble and locals have made this a First Amendment issue, and it looks as though the court is going to shine favorably upon Rumble and locals' position.
Well, let me ask you. Let me ask you a really stupid question. How is speech conduct for purposes of this law? So if I say I'm not going to vote for Ramaswamy because I don't want to smell curry in the White House, is that hateful enough to draw the scorn of the New York law? And is that conduct or is it speech?
That's a great question. And what Rumble has asserted is that I mean, the basis of that question is spot on. They've asserted that the statute is vague, right? And because it's vague, it puts an undue burden on the company to predict and to try and outrun some of these trends and the subjectivity of what is hateful conduct. The judge in that case did issue a preliminary injunction, and I've talked before on this stream and podcast about preliminary injunctions as an equitable remedy, aka a remedy that a court can grant that compels or bars certain behavior of a litigant rather than issuing a ruling, giving certain monetary damages or something like that. In this case, a court has said to the state of New York, to the Attorney General of New York, Letitia James, you are barred from enforcing this law because the plaintiff is likely to be irreparably harmed by its enforcement. And they are likely also to succeed in their lawsuit to overturn this on the merits based on a preliminary view of the facts and circumstances.
So, from 30,000 feet away, without having read the pleadings, I don't like the New York law. I mean, I'm a free speech hawk. And I do think there are existing mechanisms in the law of every state and in federal law to prohibit speech that incites hateful conduct, that incites criminal conduct. So, for example, while I can sit here in the privacy of my room and say, we should burn the Capitol down, this country is in so much trouble, let's start anew. That sounds menacing. And it sounds threatening, and it certainly is impolitique. But it's what the law would call, under Brandenburg v. Ohio, a mere abstract call for violence at some future date, and it expresses what might be a deeply held political view, and as such, that's protected speech. However, if I were to stand on the steps of the Capitol with a can of lighter fluid in one hand, a lighter in the other, and say to 50 kids, let's go run in there, and then use the identical speech, that might be deemed incitement to violence, because I would be speaking in a context that carried with it an imminent and immediate risk of harm. And so, that line is a difficult one to police. But the reason I'd asked earlier about the difference between speech and conduct is we police that line in First Amendment law and in criminal law because we recognize that speech that might be permitted incendiary, violent in some isolated context can become an invitation to actual hateful conduct. And so my fear of the New York law and laws like it is it starts to criminalize speech that is remote from conduct. And to the degree that it criminalizes or penalizes speech that is remote from conduct, it has a chilling effect on speech in core areas that we value, such as political speech or speech relating to our identity. So I think this early decision is worth noting. Do you know what the status of the litigation is right now, Mike?
So this was as of Valentine's Day. So they've, the state has been enjoined from enforcing this. This is the order, right? And there's Judge Andrew Carter from the Southern District of New York. I'll do a quick, I guess, case brief update on this tomorrow, just to let everybody know where this is going. I'll be following this. I'm very interested in this from a First Amendment perspective, as well as from a hate speech exception potential that we've discussed in this podcast, Norm. I know that that's something that you really are concerned with, and we've heard from the WEF and all sorts of other people at the Davos summit that that sort of stuff is coming to the U.S. soon. If the Southern District of New York is giving us any indication, it will be that that reality will be very harder.
No, I think it's here right now, to the degree that social media companies are governed by international norms, and we've got European standards that criminalize this sort of speech that New York seeks to do so. But New York is the first instance that I can think of, or at least where a large and influential state has embraced this theory, and in this case maybe on its way to the United States Supreme Court.
Well, and this was inspired, Norm, by the Buffalo shooting, if you remember that. And so I think we've got this phrase stochastic terrorism. You and I kind of joked about that a little bit yesterday. But the reality is right here, in the factual background, one of the earliest things that's mentioned here is the shooting that was streamed on Twitch, right? And that subsequent virality of that stream. And then in response, the governor of New York, Kathy Hochul, issuing a letter to the Office of the Attorney General, directing them to investigate the events surrounding the shooting and focusing, quote, on the specific online platforms that were used to broadcast and amplify the acts and intentions of the mass shooting, right? And she goes on to say, investigate various online platforms for civil or criminal liability for their role in promoting, facilitating, or providing a platform to plan or promote violence, which is just a wild world to be in if you're a Rumble.
Yeah, well, but you see this stochastic terrorism line all repeated over and over and over again. We've run out of time, but I want to give folks a heads up. I want to know what you guys are hearing and thinking about the World Health Organization's One Health initiative, calling for global preparedness for the next pandemic. I see some people saying, hey, U.S. out of the UN all over again. I remember that call from when I was a kid 50, 60 years ago. Should the United States be joining international compacts that assure a global response to global problems? There's an argument it should, but there's also an argument that the loss of sovereignty and the loss of a sense of significance in our own homes is problematic. Globalism, did Alex Jones say? Hey, call him a crank, but he's on to something. Hey, folks, we've talked our way through another half an hour of your time. Mike's just sent me a text. Shouldn't you be getting ready to go to court and object to things? And I wrote back saying, why not? Why bother? They're all overruled. But I do have to go, and so do you. So thank you for listening. Come back tomorrow.
Yeah, we're live on YouTube, so everyday streams are now going to be simulcast, as they say, one here on Rumble and one here on YouTube. So hey to everybody who's on another platform. And then we're also obviously on Spotify, Apple Podcasts, Google Play, and the whole portfolio of podcast distributors there. Everyday stream is going to be there as well. So please like this video, give it the thumbs up. I maintain that really helps us. Comment if you feel like it, but most importantly, the referral. Send this to a friend, a colleague, a loved one.
And send it to Kevin McCarthy and tell him to watch the first 3 or 4 minutes. Kevin, stop bullshitting and start honoring the commitments you made to the American people.
Right? Oh, man. See you tomorrow, Norm.
All right, bye.